My name is Nancy Fulton. I currently run events for more than 50,000 entertainment industry pros here in Los Angeles. And tonight we're going to be talking about employment law here in the state of California, which is an ever-changing thing, generally speaking. And this year is particularly an active exercise in learning new laws and applying them quickly. And we'll be speaking with attorney Jennifer Grady, who works with employers to become compliant. And I believe you also work with employees who are having difficulty helping their employers become compliant with California state law and the laws of the United States when it comes to employment. Is that correct?
Yes, so primarily we're outside counsel for growing businesses from startup to multinational corporations. And I like to be a teacher to help them become compliant because the consequences are huge. And then when we do get wind of people that had an issue with their employer, they weren't paid correctly, or they had some discrimination, then we would help them get compensation for that as well. So being on both sides, I know the arguments that both have and can help more people.
That sounds excellent. So with that, why don't we go ahead and dive in, and you can let us know what you're going to talk about specifically, and then we can talk a little about your background, and we'll just dive into the presentation.
Okay, great. So just a little bit about me. I'm the founder of the Grady firm. We're in Newport Beach, California. Lived in LA for 20 years, so have plenty of experience with the entertainment industry. And we, as I mentioned, work with businesses. We do immigration law, employment law, and business law. So really everything involving people and those relationships. I would say one thing for you to take away from today is get it in writing. And I definitely love being an advocate for people and helping them. It's better to spend money on an attorney up front. A lot of people say, oh, I don't need an attorney, but you would rather have one make a contract for you that's going to help you than to hire one to sue someone and maybe or maybe not recover that money. So always something to think about, to have your team of experts, lawyers, CPAs, so that you're doing it right. It really, life is hard enough, do it right the first time. So just a little bit about me, and then you can learn more about us at gradyfirm.com. And so today we're going to talk about AB5. I'm sure you've heard of it. And last election cycle, we had Prop 22, which was a response to AB5. It comes out of case law from 2018, which tried to allegedly make it more simple, but really the way that this all went down was that it made it more complicated, I think. So it's not going away. It's here. It has evolved. There was an update in September 2020 that actually affected the entertainment industry. So I do have some slides on that because it's a lot of niches. And so it really depends on which group lobbied, which one got the exemption. So law is not always, doesn't always make sense. Sometimes it matters who's on the legislative floor and who's doing the talking, really. So we're going to talk about what is AB5, why does it matter, what are the different tests and exemptions, and what do you do if you're like, oh, well, that's great, but I still want to keep them an independent contractor. Can you do that anyway? How to convert an independent contractor to an employee. And if you don't like this law, is there any hope for you, and what to do next? So again, this is not going to be legal advice, but it's a general overview to educate you so that you can spot what the issues are and then follow up with an attorney about the specific details to your situation. So every time I have a client that wants to know, what do I do here? I have them fill out a questionnaire about the job. I look at the job description. I get a description of the company, really make sure that I understand it so that I can know if you're doing what that company does, if you're kind of more like a consultant. It's just a case-by-case basis. And so AB5 went into law in 2019 under Gavin Newsom. This is really one of the first things I remember him doing, and it's been really the most significant disruption to California employment law in a long time. And so why does this matter? Because it affects you on both sides. So if you are the independent contractor, you're going to want to get a contract that's going to protect you so that the person you're working with can be more confident that they're not going to get a lawsuit from you. And then if you're the one who has either employees or independent contractors, we want to get that in writing, make sure everybody understands, because We have audits from the EDD, and so EDD is Employment Development Department, and that is the organization in California that monitors employment law. And the IRS, they want their taxes. So if you're misclassified, they're the ones that are going to be coming after you, or an employee can file a lawsuit or a labor claim. It's very easy to file a labor claim. You just really fill out a few page form. So if you are the disgruntled employee, that's the great news for you there. If you're the employer, not so great. So also over the last few years, we've seen independent contractors of the gig economy just really proliferate. It's here to stay. And so the legislature's had some challenge kind of keeping up with that and matching that. And that's really what the Prop 22 was trying to make a hybrid for. It only applies to the rideshare industry where they can earn into getting health benefits and other employment benefits. So Gavin Newsom pledged $20 million to enforce AB5, and there are penalties ranging from $5,000 to $25,000 per violation. So I don't know about you, but I like to keep the money I earn, not waste it on fines and lawsuits. That's why this is important. You may say, I don't want to spend the money on it, and it's going to cost you more, but it would cost you a whole lot more if you have to pay $30,000, $100,000, $500,000 in a lawsuit. Okay, so also we're wondering about workers' compensation. So if somebody is actually supposed to be an employee and they get injured on the job, that should be covered under workers' compensation. So if any of you have employees today and you don't have workers' compensation, you're already in violation. And so that is really where they're kind of redistributing the cost of injuries on the job. So other consequences besides tax consequences, fines, we have unemployment insurance, penalties and interest because you haven't been paying into that. And the biggest one here is the unpaid overtime and minimum wage issues. So if you are not paying someone the right minimum wage, and I do think in entertainment, perhaps people are working long hours for not the minimum wage. And so every single hour you're not getting paid, that's a penalty. So maybe I had somebody who worked somewhere for 1 year and they put him on salary when he wasn't supposed to be. And there are tests to figure out whether you're exempt or non-exempt. A lot of people get that wrong. So then when I add up all the penalties and fees and interest, he didn't get his meal times, he didn't get his rest breaks. Now we're at over $38,000 in penalties and interest. Plus you have to pay your attorney's fees, plus the winner gets their attorney's fees paid for. So if I haven't scared you enough into listening, now's the time. Okay, any questions so far?
I guess the only thing I would ask is, let's say that somebody's on a set, they happen to be, you're running a little tiny guerrilla production, somebody happens to be on a set, and maybe you've just been compensating them by paying them for meals, right? So you're the producer in the sense that you're telling people when to show up and what they're going to do, you're giving them assignments, and then somebody falls off a ladder, and then you don't have workers' compensation, you don't have any kind of insurance. Who pays for who pays for the person who maybe hurt their spine falling off the ladder? I mean, how is it the case that it's just fines for workers' compensation, or in the long run, are you also responsible for as an individual or as whatever kind of company you are for providing that that healthcare treatment that person might need for a long time?
So now you're going to get a double whammy because this person is going to fall and they're going to get injured. They're going to find an attorney. So they may be a personal injury attorney. They may, find out you don't have workers' comp. So they could sue you because you didn't have it. Then we have the fines. Then somehow we're going to find out that you should have been classified as an employee and you weren't. And so now we have all these wage and hour violations. So this one accident now has put you on the radar for all ththese different issues. Right. So the point of workers' comp.
But isn't it the case that your personal assets are also at risk? In other words, because there's no, somebody's gotten injured on the job, and my attorney told me when I didn't have workers' compensation, the one time I did have an employee about a long time ago, and he said, well, here's the problem. If that employee gets injured, they can pierce the corporate veil and they can go after your personal assets to get the treatment that person needs. And the worse they've been injured, the higher those bills are going to be, and the more of your personal assets are going to be in jeopardy. So is that true that not covering people with unemployment and workers' comp insurance means it does pierce the corporate veil, and that your personal assets are on the line?
So piercing the corporate veil is something they'd have to prove. So if you do have a corporate entity, then you're going to have to follow to make sure you're doing everything right there with your meeting minutes, not commingling funds. So piercing the corporate veil is when a plaintiff's attorney is going to try to say, well, your legal entity is just a fiction. It's just you're using it instead of yourself. So we're going to sue you for your assets. So that's why you always want to have an entity if it's appropriate. Do it correctly. Do your corporate formalities. Also, you might want to consider estate planning as well, putting your assets in a trust. So it's harder to find. You want to have like all these different walls of separation and doing things correctly. And the point of workers' comp is that we're kind of paying in to pay out later. It's like insurance. So that way your premiums might go up, but you're not going to have to pay like $20,000. And there can be investigations to see if it's a legitimate injury or if it happened when they were not on the job or things like that.
Cool. And then you also mentioned here unemployment compensation, penalties, and interest. So if I'm I've been employing somebody as a 1099 contractor, maybe as a writer or sort of a gig worker, and then, but they're working 20, 30, 50 hours a week. And then I say, okay, I'm done with you. And they apply for unemployment insurance, unemployment. If they name me as their employer, what happens?
So this happens a lot, that people lose their job, then they file an unemployment claim. Then unemployment's going to contact you. You have to file your response. And so that might tip off EDD that they're misclassified as well.
Cool. And then it becomes, then you're responsible for the unemployment. There's penalties and interest and fines because they should have access to the benefit of unemployment, like because they were a de facto employee, but you didn't pay into that program. They didn't pay into that program. So all of a sudden they don't have the coverage. So the EDD comes after you because you didn't provide.
Yeah, and it's unfair competition in a way because the person down the street is paying into all these things. When you do your payroll, they're going to take out Medicare, FICA, Social Security, unemployment insurance. Also, reimbursements. You have to reimburse for use of cell phone and different things if it's within, if they're required to use it in the scope of employment. We also have paid sick leave. So there's all these different things now that a California employer has to provide. And so when I write demand letters on behalf of employees, I have a paragraph for each one with the calculations, with the interest. And that's how you go from, maybe this was like 8,000, now it's 38,000.
So you're not really saving money by not paying. You just kind of
you're costing yourself money because it's only a matter of time before something comes up. We have our cost of doing business factor. So we want to always like have our employee handbook, have our onboarding, have them sign their W-4, their I-9, like all of these things. When I do it for clients, we have them fill out a questionnaire, and then we have a long PDF of all the different documents the employee signs. That way we know that they've been put on notice. They got all the labor posters, especially now when people are teleworking. We have those sent electronically because you may not have a home office. So many different things.
That's amazing. So you're right. I forgot that there's notices that every person who works for you is entitled to actually get before they start work.
So that's going to have your paid sick leave, your minimum wage, and there's a notice to employee, and that has your workers' comp phone number on there. Employee handbooks, I always recommend. There's different types of leave laws that are applicable. And then if you have 5 or more employees, we need to have anti-harassment training, which is always a good thing, especially in entertainment. That has to be done every 2 years.
I know. I think we invented that. Anyway, the world can thank us for that, actually. So that's excellent. So thank you. Thank you very much. It's a very interesting slide.
All right. So the short of it is the presumption in California is that a worker is considered an employee. So they're going to just assume that they're an employee. And then the burden is on you to show that they can actually be an independent contractor. So I know people throw around the term 1099, and where that comes from, that's the IRS form that an independent contractor will be issued. So you give them your W-9 with your info, then they send you back a 1099 to make sure that you report that income. But the legal term in employment law is independent contractor. And so I put this down here that independent contractors should also be responsible to ensure they're compliant as well, so that everybody's on the same page and you have a great contract with all the different details. So you're an employee unless you can prove otherwise. And who are you going to have to prove it to if there's a lawsuit or a labor claim? You don't have to convince the employee, you have to convince the EDD or the labor commissioner, things like that. You know, you don't have to convince me as the attorney, but you do have to convince me in order to kind of give my recommendation which way to go. So what is the ABC test? It's supposed to make things easier, and in a way it does. It just happens to make more people an employee, and people don't like that. So number one is that the person's free from control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of work and in fact. So this is very important. So if you were to hire a CPA or a lawyer, you're going to say, I'm going to have you do this job for me. You have a license, you have experience. I don't know how to do that. I tell you, you do it. I'm not controlling how you do the work. But if I have a paralegal or an assistant, I'm definitely controlling what she's doing. I'm giving her feedback. I'm telling her what to do. I'm giving her deadlines, giving her assignments, correcting her work. So that's kind of a distinction there. Number two, the person performs work that is outside the usual course of the hiring entity's business. So again, if you're an entertainer and you're hiring a CPA, the CPA accounting is outside of your production work. And then if you have an assistant, they're doing the same work you are. So if someone's kind of replacing you or being a second you, they're doing the same work. And three, they're customarily engaged in an independently established trade, occupation, or business of the same nature of the work that they're doing. So again, your production company, we're a law firm, totally different things. This is just kind of the basic test. And if you don't meet this test, then you're an employee unless you meet one of the exemptions. And there are many. So the AB5 law is like 6.5, eight pages long. I had printed it off in the beginning and would look at it all the time because it's just a hard one to memorize. There's so many different nuances, if this, then that. And so what are some exempt occupations? So first would be ones with a license like lawyer, architect, engineer, accountant, securities broker, dealer, or investment advisors. So not sure if anyone on the call is any of those things. Private investigators, certain licensed healthcare professionals, or insurance. So more important for you all is that there was an update in September 2020 for the entertainment industry, and this is AB 2257. So if you look up this law, you can find it easily. If you Google it, it'll be like legislative info. It'll say the purpose of it, and this came out of people complaining, people negotiating, different groups wanting to be exempt. So there's three different subsets for the entertainment industry. So we just mentioned the ABC test. So if you are one of the following, that test doesn't apply, and the Borreloa test will. And so the Borreloa, it comes from a case that's even older. The case, one of the parties was Borreloa, and it has an 11-point test about whether you can be an independent contractor. So I will show you that later, but it gives you a little bit more flexibility. And the ABC, you have to meet all three. Borreloa, you have to it's a little bit more persuasive. So later on down the line, if you're in a lawsuit or an issue, you would try to persuade and say more points fall in the independent contractor column than in the other. So if you are a recording artist, vocalist, musician, engaged in the creation of sound recordings, record producers and directors, songwriter, lyricists, composers, proofers, managing recording artists, musical engineers, mixers, photographers, independent radio promoters, and certain types of publicists. So if you meet any of these, then we're going to have to look at the Borreloa and see if you meet that test. Secondly, also music really found a challenge. Maybe you're going to go sing at a coffee shop or a small venue just one time. Am I going to be an employee? That's kind of crazy. So they're saying we go through the Borreloa test if you're doing a single engagement, unless if you're a symphony headliner or performing in a festival. Okay, and so then we have performance artists like comedians, improvisers, magicians, illusionists, and they would be exempt from ABC tests as long as they're, so this one is like very unique to them. They're free from the hiring entity's control, retain the rights to their intellectual property, set the terms of their work, negotiate their rates, and free to accept or reject individual performance. So if somebody's doing something over and over repeatedly, now that's going to start to look like an employee. If you're doing things here and there and you're, you know,
Like
Aaron,
if you were like a stand-up comic and you went to the comedy club and the comedy store and the Laugh Factory, you go around town and you do those comedy gigs. You're in control of the performance. You're in control of whether or not you take the gig or don't take the gig, and you don't have you're not penalized if you don't show up. They just get somebody to fill your space. So it's very independent. It's not,
and you ideally can negotiate your rate. I mean, maybe the venue might have a little bit more say in that, take it or leave it. But if you're maybe at a hotel or like on a cruise ship and you're performing every night, now that's going to look more like an employee. Mm-hmm. Okay, so we also have professional services, since this may overlap. If you're a marketing or graphic designer, I think that's a pretty common job position. Grant writer, fine artists, and I do believe they have changed the rule on journalists. I would have to check on that, because it was restricting to 35 per year, and that was people were just saying, fine, we'll work with journalists from California, we'll get people from another state. So if that is your area, I would definitely recommend checking for the latest on that. Mm-hmm. Okay, so we had talked about the Borreloa test. And that's going to apply to the ones that I just mentioned. So first you have to beat a 6-part test, and then you get to the Borreloa test. So number one, you have your own business. So whether you're a sole proprietor, an LLC, a corporation, you have your own location, which is separate than the hiring entity. I always think it's nice to have a virtual office. It's about maybe $100 a month. You can have a nice Class A address. Nobody needs to know your home address. I think you can collect mail. You can meet in conference rooms. That's always a good idea, but it's a different address than this, who you're working for. If they're required to have a business license in their profession, that they have one, they can set their own rates and set their own hours. Of course, it's going to have to comply with what your client wants, but usually it's like, okay, as long as the work gets done by this deadline, something like that. And customarily engaged in the same type of work that they are advertising, and they customarily and regularly exercise discretion and independent judgment in the performance of their services. And so that's where they're not going to tell you how to do your work, because you're the expert in that area. Okay, so if you don't meet any of those exemptions, really, because if we're trying to stay independent contractor, we want to see if there's anything else. And I think a lot of things might fall under the business provider contracting relationship. And so this one, we're going to show that you have your own business. So it's not enough just to say, oh, I have an LLC, because I do know some people that say, just get an LLC. It's fine. That's going to solve all your problems. That's only one of like the 11 pieces. And so what is the business service provider exemption? It's really the same thing. You're free from control. You're providing services to the business itself rather than their customers. So again, if the CPA is providing to you, they're not providing services to your clients. That's going to be a pretty big distinction. You're going to have a contract in writing, the appropriate license, or business tax registration. So keep in mind, everybody wants a piece of your pie. So we have federal taxes, we have state taxes and registration. So if you are sole proprietor, that's the only time you don't need to register with the state. But then again, you have no legal protection. So it's about $120 to set up a corporation. You will have to file separate taxes. There is a $100 a year minimum franchise tax board fee, but you have that entity protection. So if somebody trips and falls on your project, they're going to sue you. They're going to sue the venue, but would you rather be your entity than you personally? So a lot of the similar things that we talked about up there. So advertising is important. So you're going to put your business on LinkedIn. You're going to have your own website. You might have flyers. You're going to provide your own tools, vehicles, or equipment. And so other professions that have exemptions and use Borreloa or construction referral agencies. So this would be something probably like a TaskRabbit or Upwork. That's an agency providing these certain things.
So when it comes to Upwork, so some places call themselves agencies, and some people call themselves marketplaces. So does it, and is that
so we have to look and make sure it fits under here. So we might have people that are like a personal assistant or administrative assistant. Notice that's not on the list. And so even though, because you're using Upwork, if you're using somebody over and over, and they can actually do payroll for you, which is pretty interesting. But they're still an employee regardless of how you're getting them. Keep that in mind. I really think people might miss that and say, oh, it's just on Upwork. That's fine. They're not an employee, but really they might be.
Right. So it means if you overwork them, or if they get, or if you somehow, whether the way it's working out, they're not making at least the minimum wage, then they can come back and say, hey, you're paying me through Upwork, and I can prove how much you were paying me, and you were making me work more hours than I was supposed to for the money that I was supposed to be earning. And so now we have an employment situation that's developed.
So you're also setting the rate on there, so it's going to be very obvious with an Upwork situation, because you do log in. You can even do a special service where it's kind of tracking when you're on the computer and when you switch browsers, I think. But you're still going to have to pay them the minimum wage of where they are in their state and in their county. Remember, I think we have 22 cities or counties in California that have their own minimum wage and their own paid sick leave. So you may want someone from another state. It might be easier, and their minimum wage might be less. I mean, you might be working with people from another country, so that's not going to be under California employment law. But if they are located in California, it's at least $12, $13 an hour minimum, and it could be higher in certain cities.
Right.
All right. So if you have determined that your job or profession falls under one of these exceptions, then we have to go to the Borreloa test. So if we said earlier, you have to do the first part and then you go to Borreloa. So what is the Borreloa test? Pretty much kind of what we've been talking about, whether they're engaged in a distinct profession, part of the regular business, that's a pretty big piece, whether they supply their own materials, equipment, the alleged investment that they make. And so if you are someone who has your own equipment, I mean, more than just a laptop, you have a particular, I would think in entertainment, people might have expensive cameras, different, equipment, there's investment there. Whether the service requires a special skill, whether it's usually done.
So if you're a sound engineer and you have a DAT drive and expensive sound recording equipment, that's a good indication that you might be able to be considered a contractor rather than an employee, because you're bringing more to the table than a standard employee would be. And also you're doing your work in a different way. But if you're working for a producer and the producer is actually producing media, aren't you sort of working in the same industry? So wouldn't it necessarily, I mean, that weighs on the other side, which says I'm producing content to these guys' specification. I have to meet their requirements. They're telling me when I have to show up. So this is the thing where you have to balance these two sets of factors to see which way it leans in terms of how many checks are in the contractor column or the independent business column, and how many are in the employee column.
And the closer to 11, the better, I would say.
If you want to call them a contractor, you want to get 11 checks in the.
Yeah, 11 would be best, at least 9 out of 11. If we only have 5, then I don't think that sounds too good. So then just to finish this off, the alleged opportunity for profit or loss, depending on their skill, length of time which the services are to be performed. So maybe it's a one-time thing or a certain period of time, as opposed to just ongoing indefinite, then that might sound more like an employee. Method of payment, whether by type of job, whether they have the right to fire at will or breach of contract, and whether or not they think they're creating an employer-employee relationship. So when I do say, okay, I think that this really can be an independent contract relationship, I create a contract. It's probably 8 pages long. And specifically for this, I went through and I put the checklist and I put all these in a box and I have them check yes, I have a business license. Yes, I provide my own materials. I even have them initial it, so that we say to everybody, okay, we know what's happening. And then it says, we agree to an independent contract relationship. We agree there's no workers' comp. We agree there's no unemployment insurance, things like that. And then I even, started putting their articles of incorporation and their business license and a screenshot of their website at the end. And so I knew I was working on this for a client, and the person was really kind of fighting on that, and they didn't want to put it. I didn't really know why you would take it out. And she was a little bit too obstreperous, so they ended up not moving forward with that relationship. I just didn't understand why we're spending so much time going back and forth. It's to protect both of you, really.
Mhm.
So how do the Borreloa test and the ABC test compare? So the ABC test requires the employer meets all three elements of the test to not be an employee. And under Borreloa, no single factor determines, but we're going to look at the totality of the circumstances.
Mhm.
And so that's why it is somewhat subjective. And I think, the good part of the intent for this law is to say, let's just make it easy, because otherwise you can talk to this lawyer, they're going to say, it depends whose lawyer it is. If they're defending you, they're going to say they're not an employee. If it's you want the benefits, you're going to say you are. And so there is a lot of uncertainty in that regard. So that's how we got to this point. So what should you do? Hire qualified California licensed attorney, somebody who specializes in this. So it's going to be an employment lawyer, and it's going to be a lawyer who has experience doing this. Then decide what you want to do. Do you want them to be, they're going to give you a recommendation whether they should be independent contractor or an employee. And then you're either going to want to make a compliant contract or do all the employment onboarding. So I would say after this call, you're going to have a decision to make, and you're going to have to do something, because you probably don't have a contract. If you do, you might have gotten it off the internet. Never recommend just downloading a contract, because it's not going to be specific to you. It might have wrong clauses in there. And then the employment, there are a lot of things that you have to do it right. And I would say I've never had a client that had all the different pieces in their onboarding packet correctly. It's just something we've been collecting and researching over the years, and it changes and it's updating, and the law changes all the time. So it's a good time for you to get a lawyer that can help with contracts and with all of the employment thing as you grow. And then you want to always have client services agreement with your clients. Anytime there is money in exchange for time, you want to have that in writing, set out those expectations. What happens if it doesn't work out, if there's a breach, if they don't perform? We want to have all of that.
Mhm.
So then if they are able to be an independent contractor, we want to preserve the evidence of that. That's why I asked specifically for their business license, their articles, their advertising, and then you're going to draft your agreement. And if they need to be an employee, now we have more steps. So we want to notify them that they're an employee. I always recommend an offer letter, not a contract, because the contract is going to maybe bind you to a specific period of time. And California is an at-will state, which means that either party can end the relationship for any reason or no reason, as long as it's not illegal. So that comes out later when they say you terminated me for an illegal purpose, but ultimately you both have the opportunity to end the relationship.
And that would be like if you fired somebody who was pregnant, or you fired somebody when you found out they had a disability, or you fired somebody for getting injured on the job, and because you didn't want to, or because they wanted to take a vacation that they had vacation hours they'd accrued, and you wanted to fire them because you didn't ever want them to take a vacation, right? It's like you're violating employment law.
Yes, and then so we have federal law, which has protected classes, and then California, the list is at least twice as long, all the way down to your hairstyle as a protected class, gender identity, different things like that. So there's more protections in California.
Cool.
So then we want to onboard them with giving them all the labor posters, a notice to employee handbook, I-9, W-4, and the I-9 is due within 3 days of hire. That's a federal document to show that they have the right to work in the United States. You do have to look at their documents in person. That could either be a passport or, for example, social security card and driver's license. You have to look at it and inspect it. There was a brief moratorium on that for remote workers where you could do that virtually, but that's only in that specific context due to COVID. We want to get payroll and benefits. So the benefits aren't required. I think maybe if you're over a certain size, you want to speak to that. But as a small employer, I do recommend you get a payroll company rather than your accountant, because they're going to do this every 2 weeks. You're going to have a wage statement that shows all the line items. And you're still responsible. You can't just blame the payroll company and say they didn't do it right and I'm off the hook. So you have to have a good conversation and make sure you're telling them everything, like what city you're in, your minimum wage, your paid sick leave is different based on that. So I always tell my payroll provider, okay, where each person is and if things are changing.
When you're working in the entertainment industry, because you also have union benefits that you have to accommodate, and also because sometimes you're hiring people for as little as 8 hours or 10 hours, you're bringing extras in for a day. And when you're working with SAG, so when you're working with SAG, they have a bond that they make you put up because they do actually like it when their folks get paid. And what SAG does is, if you're working with one of the payroll companies or the employer of record companies that they work with, which do things the way that they like them done and make sure everybody gets paid, and they have all the right protections in place and put money into the right healthcare accounts, because they have very good healthcare benefits. The employer of record has this whole set of things that you sign. They do and they also file all of the tax documents, like the W-2s, and at the end of the year they handle all the employer side of the document processing, and they also have sort of the standard language things that you mentioned in step 4. When it comes to working with when you're working outside of the entertainment industry, or when you're working as, that's when you're working on set. It's not really necessarily the same when you're working in a production company or where you're developing content, or you're working for a management company, because that's a regular office. That's not covered by, there's not, things get more complicated in those situations because you don't have the union specifying exactly how they want things to be done. So are there
we have a checklist that we've made that is
right.
the different stages. So
right.
prior to hire, at the time of hire, during employment, and at the time of termination.
Right.
It has all the things like, okay, your paycheck, when is that due? If they quit that day, then it's due within 72 hours. If they give you notice or you're terminating them, everything is due the last day. So final paycheck, all their vacation, all that. So there is no like central database where you get this. So we've just kind of aggregated it from all the places. So if you're doing things with the union, you may have collective bargaining agreements.
Yeah.
You would want to check if there is an exemption wage order for your particular line of entertainment. So apart from that, then everything would fall under what I'm saying.
That makes well, you're actually, all the stuff that you're talking about is stuff that whether you're working on set with union or non-union employees, all of these things have to get done. When you're working with union employees, there's this additional set of things that have to be done because the unions require it. Not just the SAG, but also IATSE and all of the other ones that work with the specific guild trades. So it's a very interesting list, actually. This is.
Yes, I wouldn't just rely on that. I mean, the union's going to get what they want, but you still have to do.
Well, yeah, the employer has their own thing. Actually, most of the time you have a law firm that works with you as well, right? You do have both things when you're running a production company.
And then we give a W-2 instead of the end of the year. You're either going to get a 1099 or a W-2.
Right.
And then I just still want to reiterate, there is paid sick leave law in California. So minimum 3 days per year. If you're in Los Angeles, minimum 6 days per year. There's different ways you can accrue it, or you can give it all up front. Then right now we have a new COVID sick leave until September 2021, and that's an extra 80 hours if you have 25 or more employees, and that counts for getting vaccinations, taking care of someone or your own. So you kind of have to be on the mailing list to know what all of these are. And we do have a newsletter. You can sign up for that on our website, gradyfirm.com, and we always kind of push out all of these news updates.
That's very cool.
So then most importantly, I would say, is to create a personnel file and keep good records. If this was a test, I would say I never had a client get percent, even the most on top of things. You're busy, you've got a lot of things to do. That's the last thing you want to do. Maybe you hate paperwork. If you hate it, hire somebody who can do that for you. Put it in a secure server, put it in a locked file cabinet, make sure other people don't have access to it. And you want to keep that, for many years. Employment lawsuits can go out at least 3 years. So you want to have that too. Remember, the burden is on you. So if they're an employee, you want to have a time clock. You can sign in from your phone or from a computer. We have GPS ones. We want to show that they're getting their meal and rest breaks. So for every 4 hours work, they get a 10-minute rest break. By the 5th hour, they're going to get a 30-minute meal break. If they work 10 hours, you're going to get time and a half over 8 hours. If they work over 10 hours, they're going to get double time between 10 and 12, and they're going to get a second meal break. So all of these are located in wage orders. You want to talk with an attorney about making sure you're doing that correctly. So, when this first came out, everybody was up in arms about it. So what can you do? Lorena Gonzalez is the author of AB5. You can contact her. I think they have done some negotiations over the last year, but we'll see if this continues to get refined.
Mm-hmm.
And so we have a guide, we have all sorts of information on our website. We have an AB5 page, we have a COVID-19 page, we have lots of resources. And then of course the recording of this, if you want to listen to it again. And then we have a handout that you should be able to download. If not, you can email me at info@gradyfirm.com, and that's like a 1-page sheet, which is a summary of what we've talked about today, just to really distill it into very simple terms. And then you can follow us on social media. And then book a 15-minute consultation. And so we do kind of to go with the acronym of ABC, we do the analysis, building out your employment paperwork or preparing contracts for you.
That sounds great. And cool. So with your permission, I want to just sort of follow up with just a couple of questions. You mentioned that there is a, if people Google wage theft, anyone can actually Google wage theft. They'll find it on the, and it'll be taken to a site on the as a California state government website, and they can actually indicate that they've been made less than minimum wage, or they haven't been paid for overtime, or they've been treated like a contractor when really they're an employee, or they've all of these kinds of things. If somebody feels like, for whatever reason they've been treated badly as an employee, should they go to the forum and file a complaint and have the state directly reach out to the employer to handle the problem, or does it make sense for them to go see a lawyer and try to find a way to mediate the problem, which might be better for the employer in the long run? Would it be? And my understanding is that might make it be more profitable or more provide more benefit to the employee. Is that true? I mean, what do you think?
The way that it's set up is you can file a claim with the Labor Commissioner, and it's supposed to be so easy that anybody can do it without an attorney. It's trying to level the playing field. Downside is it could be 1 to 2 years before you get a hearing. So the last one I did, it took at least 2 months before they actually gave the notice to the employer, but we were able to use it as leverage. I personally discourage litigation because it takes 2 to 3 years. It takes your time. It's emotionally incredibly draining, and it's public. And so not only is that available for your future employer to see, anyone can Google your name or look in the court documents and see that there. So I always try to resolve things with letter writing first, and you're going to need some leverage. So you can do it yourself, but if you have a lawyer, they might take a cut of it or maybe charge you hourly, but they're gonna do a much more thorough job ideally. So you may think it's one thing, but then when we do all the math, I might come up with 11 different violations, and maybe you only came up with one. So now that's gonna give you so much more money. Somebody to guide you and help make sure that you're doing it correctly.
So in that case, the lawyer is using the fact that it's so easy for people to actually file that, and they're basically go to the employer and say, okay, here's a set of violations that seem to be apparent and which we believe we can prove. We can go to the state and file this complaint, which is criminal, right? So wage theft is actually a crime. It's not. It's prosecuted as a crime. It's not a civil matter. The state actually prosecutes it just like they might prosecute robbery, right? Or tax evasion. Is that correct? In other words,
What I do is always in civil. It's always civil. Yeah. I mean,
okay, because when I've gone up to the wage theft website, it actually says it's a crime, and it talks about potential jail time. So I guess that, in other words, that seems different than a sort of a normal civil case. When your attorney's handling it, then it's a civil case. But if the report is made to the state just does that thing the state does, because they just consider it a crime. Isn't that correct? Or
that might be if it's egregious or if it's multiple violations. I think it's going to be fines first. But really, what we're talking about is, all right, you didn't pay my minimum wage, didn't get meal and rest breaks, didn't get cell phone reimbursement, didn't get paid sick leave. We're going to add all these up, and in the claim, there's actually a chart. And you're going to put that in and answer some questions. And so it's going to be very easy for them to know if what you're saying is true. And they're like, oh, you know what? You got us. You got a good claim. Or they're like, you know what? No. And then they're going to contest it. And so that's where the back and forth goes. It can take months to do that. And so you're going to ask for a number here. They're going to offer you a number like under 10,000. And ideally, you might meet in the middle. And the thing about negotiation, the last one I did, so they didn't have a lot of money, and they showed me their tax returns, and maybe they're hiding money, maybe they aren't. But at the end of the day, I was like, I don't think that you're going to get that money. 2 years from now, they may be bankrupt. They may not exist. So taking the money that they can offer you today might be worth it. And that's a decision you're going to have to make. Everybody wants their day in court if they think they're going to come away with millions. But I think those are more the exception.
Right. Well, I think especially if it's more people that are making the claim as opposed to just a single person. So
they're going to have a class action, perhaps, if their claims are similar. So there were one, do we get paid for the time it takes to put our uniform on? That was a class action. Everybody got, the lawyer wins the most there because they get a big part of this pot, and then you might get, $30 or $200.
So when the other question I wanted to ask is, one of the reasons that employers don't want to even get into this whole dialogue is if they are prosecuted for wage theft, if somebody does make a report, or if for whatever reason it does get reported to the state of California, then the EDD and the IRS and other people all of a sudden get an alert as well that there's tax issues involved. So it's not just it's not just the employee that's a problem. It's not just the fact that the employee wants compensation. It's like all these other people go, you were disobeying the law, so now we're going to have to take a good look at you. You're like on this radar. So you don't want to get on anybody's radar. You just want to be able to shoot your films or produce your apps and not have to deal with any of these hassles, which is why you take action in advance rather than waiting to be surprised later by the status of your employees.
Yes, below the radar, because you're doing it right is best. And keep in mind, people talk, they should have a confidentiality agreement in their settlement. Somehow people find out, there's this one organization that I've had no less than 5 employees call me about, overworked, not getting, I was misclassified. So somehow word gets around. So someone else might come after you too.
Cool. So when, and we talked about the fact if somebody thinks they were employed by you, they don't, especially when they're younger workers, or let's say there's somebody that, you hired who right out of college or something, or they're interns, and then they file for unemployment because they thought they were an employee because they just don't know any better. Next thing you know, the unemployment office is irritated with you. So
I'd like to make a statement about interns. So a lot of people think, oh, it's just an intern or volunteer. If it's an intern, there's at least a 6-part test, and you have to show that they're doing this for school credit. They're getting a benefit. It's not just you having doing the work of a regular employee. So I do think a lot of people miss that. I think the easier thing is just pay them the minimum wage and call them an employee, even if it's only for 3 months.
Right.
They can be a temporary employee.
Right. And I think Hollywood, we've contributed so much to so many laws, but I think if I'm not mistaken, I think that one of the biggest internship lawsuits had to do with Hollywood interns that would be working for, 10 or 12 hours a day for 6 or 7 months for production companies. And they were called interns, and they would do it. They wouldn't get any college credit. In fact, it would make it harder for them to go to school. because it was.
Yeah, it sounds great for the employer. And I know, entertainment is so hard to get into. People are willing a lot of times to do anything, but this is where, you're going to know your rights now. And unfortunately, I don't know if that might mean you might not get the job, but go somewhere where you are getting paid for your time.
Well, I think now because of that has happened, I think Hollywood has decided to just hire more minimum wage. They just started paying them the as employees and stopped calling them interns and making them work as if they were employees. Is there one of the things I think when we're corresponding about this particular topic, I think I'd mentioned that I've been told recently that it seems likely that a lot of aspects of AB5 look like they may be going up to the national employment market. And so when people choose to leave a state, like they say, well, I'm going to shoot outside California. I'm going to produce my app. I'm going to go to Georgia or some weird thing. That doesn't necessarily mean that over the course of the next 2 or 3 years that's going to be an escape. Because
you have to look at the law in each state. So that's why it's hard sometimes. I have clients in multiple states because I have to look up the law everywhere. And it's going to matter if you're working in Georgia now, you have to know what does Georgia require. I think Florida has a similar independent contractor law. I think, Texas may be more friendly, but I would say anything that California did, people pick up, same-sex marriage, marijuana, like all those things we did at first, and then other states catch on. So this one, I think it's about half the states do have this type of law.
Right. So just identifying somebody, just saying somebody's a contractor, or just saying I'm a contractor, doesn't really necessarily doesn't achieve the objective of removing the liabilities. From an as an employee side, I want to transition into finding out what the questions the audience has is in just a minute. But from an employee side, I think, do you think a lot of them, a lot of people who work under the table, are they conscious of the fact that of the risks that they are taking on behalf of the employer? In other words, all of a sudden you're shouldering your own risk for getting injured, and you're shouldering your own risks for working overtime, because there's no laws. So you actually have to look at your boss, at hour 15 and go, well, I'm only getting paid $15 an hour. I want to go home now. And then if he thinks you're a contractor, he just fires you. And there's an interesting, or you're out in the middle of the night, you're loading trucks, or they break down these sets at you have like a 10-hour day generally. Sometimes you have a 12-hour day, so you're loading the truck. Everybody's really tired at the end of the day. That is when people get hurt. When that happens, if you're a 1099 contractor, if you get injured at that time, because other people on the crew are actually tired, you're going to bear the cost of that injury.
To a civil lawsuit. So okay, so you're injured, you still have rights if you're injured within the scope. So if it's a premises liability, meaning you got injured in the location, you're going to sue the location, and kind of probably 3 different people, and they're going to all try to get out of it. So I think no matter who you are, at the end of this call, you need to know, are you an independent contractor or an employee? And are the people you're working for you, are they an independent contractor or an employee? Like, we don't want to get to where you're injured and it's a surprise and now we don't know what you are. Like,
and now we don't know that's not a good time to figure out that you were an employee, right? Oh, by the way, I was an employee. Or I was a contractor, who knew? So
yeah, and if you are, you think whatever you think doesn't mean what it is. Like, you need a lawyer to say this is what you are under the law, under your job duties and stuff. So it's not about, I think a lot of people want to be a contractor. A lot of my clients will say, oh, but they say they want to be an independent contractor because they want to hold on to the tax money and not pay it out. And now what happens when April comes? Now you may owe thousands of dollars. You probably don't have it because you already spent it. And you haven't been paying into Social Security. So when you get to retirement age, what do you have for you there? You're not getting benefits that you're entitled to. So you may want to look at that from a different perspective and see
as an employee,
you have more benefits and protections as an employee. So sometimes I don't understand why people don't want to be that. I mean, if you're the employer, obviously it's a greater burden. But
I think people need to decide what they are, and I also think they need to they need to make sure that the employer understands it doesn't redefine what they are. Just because an employer says, well, I'm going to treat you like a contractor, but here's a list of things you're going to do. It's like, well, yes, except that list of things means I'm not, just so you know.
Yeah, that's what I'm saying. It's like not your necessarily decision. It's what are the job duties and how does it relate to what the company
Well, I
does?
think that was a really important point that you made, that it's not a choice. It is a fact. It is the pattern of facts determines what this is. Actually, one of the guests, one of the listeners asked, what advice would you give to an employee who's afraid of burning bridges with a studio or production company by filing a claim for violating labor law? So I think people, even if you're an employee and even if you know your rights have been violated, as an attorney, what do you tell clients who come in and go, well, they really have harmed me, but I am afraid to do anything about it?
Okay, so I would start with the demand letter to keep it private and let them know. And, it is a wake up call for them as well. And if they're smart, they're going to figure out what they've done wrong and what to do better next time, and then pay you and keep, make a settlement and move on before they do this to more people. I mean, there is the issue of burning bridges, but there also are non-retaliation laws. So now they are retaliating against you if you bring this. So there's what the law is, and then there's the practical, what happens in real life. So there is that delicate balance. But I mean, if it's significant, then it's worth exploring, and you don't have to be contentious. I think a lot of lawyers are jerks. I find they're the ones that don't know the law, and they're not that as good. They just make a bigger, they roar louder than what the facts are. So I think you can do it in a respectful, like, this is what it is. I should be compensated. And
right. Do you think it's better when somebody finds himself in that situation to approach an attorney first, or especially if they know that they've really been harmed, or do you think it's better if they try to resolve it with the employer directly without having an attorney involved?
well, they probably don't know like what their rights are. So that's why you would want to speak with an attorney, because they're going to know what all the violations are and you're going to have more leverage. You can do it yourself. A lot of times, if people are still employed, I will have the employee do it themselves, and I'm in the background ghostwriting their emails or doing it. Maybe they don't even tell them they've talked to an attorney. Or I've had a lot of people in the last year get threatened with like a final warning because somebody brought a complaint. And I really sided with my employee who was getting the brunt of this. And so I helped write things behind the scenes to try to keep them from getting fired and to turn that around for them. So you want to have an advocate.
So you're saying that as an attorney, you can work with people without to try to mediate from the background as long as it's possible. And then if you just can't be done, you can step in, and meanwhile, but you can coach them through this process.
Yeah. So I think it's good to be discreet. And it's a lot of times they like the job. They've been there 15 years. They've worked there. They don't want to lose the job for all sorts of obvious reasons. And so I ask them, the first question is, what's your goal? Oh, I want to keep the job. Okay, well then let's figure out how to do this delicately to keep that. And if it doesn't work out and you get fired, you've started keeping a record, saving emails, writing things down, taking notes, so that later on, if you do have a case, you have evidence. Because once you're gone, you can't access anything anymore. And so you have to go through a lawsuit and discovery to get that, and they may not produce those records for you.
So that actually is really very important to know. It's like getting an attorney involved just to advise you early rather than waiting until the last minute. So we have a question.
Contingency. So, I mean, you want to find that out. Like, is this an hourly engagement? Is this something that you do it and take 35%? You're going to make that arrangement, or maybe you can pay for a half hour, 1 hour consultation, and that's going to give you. Sometimes I'm able to give people that kind of boost, and then they go and take care of it themselves.
Oh, that actually makes good sense. When it comes to somebody asked about non-union films. Can an independent producer hire a cinematographer, lighting and sound people who have their own gear as independent contractors for 15 days? And is this when it comes down to the whole, it's not about whether you're an independent contractor, and it's not about what their titles are, it's whether or not they meet the tests that you talked about?
Right. So first we would look at the ABC tests. If we don't meet that, then we're going to want to look to the exemptions. We have the different entertainment ones. And if they were under those, then we go and we look at the Borreloa test. So, are you, a cameraman and that's your job and you're freelance to a lot of people, you're still going to want to have that contract that shows that you meet all the requirements. And you have to have a contract always, especially if you're a freelancer. I think you leave too much on the table and too much doubt. And so many times I write them and then clients come back and have me sue some, not sue, but they're like, this person isn't doing what they said they did. So then I have to write them an email and quote the section in the contract. And that is so much better than, when we started working and they didn't have that contract to refer to. I had very little teeth, but once you have it, then it gets people to respond much better.
I think, well, I'm actually a big believer in, like, no matter who you're working with, it's very nice to have a piece of paper that talks about what people are going to do instead of just figuring it out in the middle of trying to do it. I think people a lot of times have a question about, everybody's certainly got a right to do all kinds of different things. If I'm an individual and I want to work for free on a particular project because I'm passionate about it, is it the case that I can't choose to donate my time to something? And let's say, for example, I want to do a short film with 5 of my friends because I want to produce a project. And maybe one of them's calling themselves the producer and one of them's doing this, but we're really sort of doing it all together as a joint project. Are those kinds of projects risky as well from anybody's perspective?
Okay, so what if your film makes it big, goes to a film festival, ultimately gets picked up? I mean, look at just Facebook alone. We have 3 guys in the dorm and ends up being the biggest thing to ever happen. And there were lawsuits about that, and there were emails showing that I think it was their idea. So I think, employment aside, you need a contract for anything you're doing, especially even a startup. Maybe we don't have any money now, but what if your idea takes off and it's worth millions? Definitely people are going to fight over that. You're going to want to have that in writing. But you said about the volunteer, the first case that I did when I went out on my own was a bookstore, and they had volunteers come in to work, and they said, well, they wanted to volunteer. And then the person who did, the lawyer said, showed the law showing that's unfair competition, didn't pay minimum wage, didn't do meal and rest breaks, and we were able to get out of it for a pretty shockingly low amount. But I think you're not always going to be that fortunate,
shall we say?
Yeah. So just because they want to volunteer, I think you can get in trouble.
Well, I think the word volunteer isn't that sort of a legally volunteer? It really is a legally defined term too. There are definitions of what's a volunteer and what's not a volunteer.
Maybe if it's a nonprofit or something like that.
Yeah.
Because you're not. Yeah. But still, I would really consider just always, when in doubt, pay minimum wage.
Yeah, it seems like it'd be so easy. And finally, you have we have a question you talk about remote workers. And here inside the United States, if I'm hiring people, somebody's hiring somebody in California, whether they know it or not, and the person is behaving as an employee, even though the employer is out of state, that out of state employer that now has this California employee is obligated to obey California state law. Is that correct?
So it depends where your person is working. So I have an employee who's in another state, and I had to go look up the law in his state, do employment onboarding documents there, sign up with that state's EDD. But I think you might be asking about a foreign person from another country. So they're going to be outside our U.S. jurisdiction. So that's going to be a contractual matter. So you would still want to have an independent contractor agreement.
Right. So if it's somebody who's working outside the country, then even if that person's a U.S. employee, they're working outside the country, so the same laws don't apply to them. Because their location determines that.
That's a very specific nuance. So we did have a client who someone wanted to go back to Japan to, I think she was from there. And it was like for a very short time, we can keep it under California as like a temporary situation, but at a certain threshold, we need to look into the laws of Japan. And so then we had like a third party that could be the employer in that company, and they declined to do that. And they said, no, you have to come home or you can't work here anymore. Because it was going to cost them a lot of money to set up something like that. Sometimes the employee is worth it, and you need to create, there are like the PEOs that can be the employer of record in a certain company, there's different reasons why you might want to do that. But I think, you know, if you're someone in India who's doing like graphic design or something like that, then you would want to have a contract. You're going to want an international arbitration agreement. Since now we have courts in different countries, that's really hard to enforce, honestly. But you can do it if you set it up correctly.
Yeah, I think the only reason I ask is because sometimes you have an employee who, because production goes worldwide, so every so often somebody will be, just because if I travel to Romania to shoot something, you know, California labor laws still apply because I'm a Californian and the production company is, you know, California. We're still having laws, you know. So and when people are traveling remotely, sometimes folks become a little lax on the compliance side.
Right, but the employee may not relax in their claims. So
yeah, I guess you should get the employee to go along with that laxity, shouldn't they?
you're abroad, doesn't, you know, things are out the window. And other things you need to keep in mind are jurisdictions. So for example, Los Angeles, if you work there at least 2 hours a week, now you have to pay their sick leave. So remember, California is 3 days a year. LA is 6. So if they work there just 2 hours a week, now they get the 6. So you have to go with the higher rate. So we have to look at all the different cities. You know, I think Santa Monica was 5 hours, 5 days.
Yeah, it's different.
San Francisco has the most employee friendly everything. Even I think you have to pay for, you know, restaurant healthcare, restaurant worker healthcare and things like that. So wherever you are, wherever your employees are, you want to look that up. Go to the city's website, ask, you know, call their department and have your lawyer help you figure that out.
Really, you probably have to have a lawyer when you're employing people. You probably have to have a lawyer handle it because nobody's going to be able to keep track of all of those different kinds of things. And even your lawyer may decide, well, we're going to, you know, you're only hiring 3 guys and you don't really want to have any management issues. We'll use an employer of record, but you're creating intellectual property. So you still need to have work for hire agreements that make it so the content they create actually does belong to you. You know, and non-disclosures and whatever else you're going to do. Like I think there's a role for an attorney in almost every company that's creating intellectual property, I think. And I think most of the people that I support, as I mentioned when we started, are more than 50% of them are producers, filmmakers. About 25% are writers and screenwriters who are selling intellectual property, and they get hired to write all the time. And don't even talk about how many hours, because that is just a humorous conversation right there. You know, it's like, you know, I want this script done. It's got to have all these changes, and this is the 15th draft. And then the rest of them, a lot of the rest of them are startup companies who are hiring people to program or to develop content, develop intellectual property. I don't think any of those people should be doing business without an attorney to guide them on employment issues, not to mention the intellectual property issues. Just,
I mean, in entertainment, what are you selling? It's not a product, it's an idea, it's a work of art. That's the foundation of what you're doing. And so if somebody steals that from you or reproduces it illegally, that's taking away from your profits and your values. So
it's your livelihood. And also the other thing is that if you're a producer, when you sell your intellectual property, you're gathering all this intellectual property from all these different people, and you're turning it into a finished product. And then you're selling that thing. You're selling a piece of combined and created intellectual property. So yeah, you probably need an attorney because you're taking work from so many people, and you're going to end up selling that to a distributor or to other people. And if you don't have an attorney to have secured all those rights and turned it into the bundle you're going to sell, the attorneys were your best friend, really. They're the ones that make it so you have a product.
I would say invest in your good IP agreements and then like a set of employment documents, and then you can modify them. I mean, I still like to do each employee because everything is different. Law has changed since the last time I gave a template, but if nothing else, have your template, your client services agreement. And then you can have, I like to have an addendum or like exhibit at the end that we can change. So the contract we can use over and over. And the last page is the terms of this agreement. So that's kind of a flexible way so that you know, just spend the money on that first important draft, but have something repeatable and reusable. But if you are in like high stakes things and you are going to be picked up by a studio that you like, this could be worth millions of dollars, so make pay a few thousand to get a good agreement. Yeah.
I think you might as well.
Yeah.
So anyway, just how hard could it be? So cool. Well, I want to thank you very much for taking the time to chat with me. Would it be all right if people have questions or if they have concerns about their employment environment, or if they're a producer and they're thinking about putting together a production, is it okay if they sort of reach out to you to sort of talk about their situation? Uh, do you have like, I think in you mentioned you have a 15-minute consultation. They can reach out to you and sort of discuss the situation that they're in, and you can sort of counsel them as to whether or not they should work with you or with another attorney to resolve the issues.
Yeah, so you can email me at info@gradyfirm.com, or you can go ahead and book the call directly on our website on the schedule page, and then we chat and learn a little bit more about you, and where's the best place to go from there. What is it that you need? And if I can't help you, I can always find someone who will.
That is very cool. Well, I want to thank you very much for taking the time to speak with us tonight. It was truly kind of you. And I think that the ABC test, the Borreloa test, and the fact that you address so many of the different issues that are involved in both production as well as, what it takes to be a contractor, what it takes to hire a contractor, what it takes to hire employees was really valuable.
Great. Well, if you ever want to talk about any other topics, let me know. And it was a pleasure being your guest.
Cool. Would you like, do you normally, I make the recordings available to people after the call and to members going forward. With your permission, I'll go ahead and edit this up and send you a copy, and then you can decide whether or not you want me to make it available to people going forward.
Yeah, that's perfect. We can do that. And I can put it on my AB5 page.
Oh, well, I have a feeling your AB5 page is just going to become so much longer. All right. Well, thank you so much. And I look forward to speaking to you over the course of the next, it'll take me probably 72 hours to edit this up, and then I'll make it available for you to review. And if you say it's okay, I'll review it, make it available to the folks I support.
Absolutely. Okay. Well, it was a pleasure, and have a great rest of the night.
Excellent. Talk to you soon.
Thank you. Bye-bye.
Bye-bye.